Okay, welcome back everyone. All right, do we have everyone here? Yes, okay. All right. So welcome to the second session of our Australian Equality and Law Forum. My name, if you missed the first session, my name is Belinda Smith and I'm co-hosting with Simon Rice. We have two very eminent speakers for this session on disability. We have Rosemary KS and Therese Sands, and I will introduce them in a moment. Just to start with, I thought I'd let you know the format for this session, which is after I introduce our speakers, I intend to conduct a question and answer session with the two as panelists. I'm going to pose questions to them about their research report, questions that arose for me, and I thought, I'm chair, I can dominate this in terms of the starting part of this session and pose the questions that I wanted to have answered or explored. We're hoping that part of the session will go for no more than 40 minutes, and then we will move on to questions and answers. So during those 40 minutes, like in the first session, if you have questions, we invite you to pose those in the Q&A section of the Zoom. Okay, so let me get started. Can I start by introducing Rosemary KS? Rosemary is an accomplished human rights lawyer and a legal academic. Many of you will know her already. She's a senior lecturer in the Faculty of Law at UNSW. The Director Engagement at the Disability Innovation Institute at UNSW, the winner of the 2019 Australian Human Rights Medal, and is currently, appropriately, serving a 4-year term on the United Nations Committee on the Rights of Persons with Disabilities, and last year was appointed its Vice Chair. Equally impressive, we have Therese Sands, who has worked for over 25 years in education, policy development, capacity building and advocacy in the area of human rights and disability. She is the former director of Disabled People's Organisations Australia and the former co-CEO of People with Disability Australia. Therese currently provides research and policy coordination for Rosemary in her role as Vice Chair of the UN Committee. So thank you both for joining us and sharing your insights. Let's get started. Can I just check that everyone has the, my screen is showing Simon in the middle of it rather than a regular gallery screen. That might be just my setting. I can change it. Here we go. All right. So let's get started with Rosemary and Therese. As I mentioned, you co-authored a research report. It is entitled Convention on the Rights of Persons with Disabilities, Shining a Light on Social Transformation. You were commissioned to write this report by the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with Disability. Could you each describe why it was important for you to write this report?
I'm happy to start off, Belinda. Good morning everybody.
Good morning.
Look, apart from the fact that it's my job at the university to do commission research, the reason I thought this is a particularly important piece was the Royal Commission had been fought for a long time by people with disability. And it was really, really important to me, from my perspective, that that work be grounded in human rights. Australia had made significant commitments to the CRPD, it ratified in 2008. The CRPD is mentioned in lots of policy, but it's not reflected in the reform process or the practice that we see on the ground. So change was not happening, rather, even though we were seeing policy talk about CRPD and human rights, there wasn't a lot of traction. So we saw, well, I saw this and Therese agreed with me that this was an opportunity to operationalise the CRPD for the Commission, to try and get some truly human rights based recommendations from the Royal Commission to actually get some policy reform traction.
And Therese?
Hi, everyone. Sorry, I'll just get off mute. Look, just following on, I suppose, from what Rosemary has said, I mean, I had been involved for, over a decade with in disability advocacy for the establishment of the Royal Commission. So the issue of violence and abuse, neglect and exploitation of people with disability was just a critical issue, just a constant theme in the lives of people with disability. So it was also the fact that we were also advocating, once the Royal Commission was established, that the terms of reference were grounded in human rights. And one of the terms of reference does, speak to international obligations, specifically the Convention on the Rights of Persons with Disabilities. So that was a critical factor. And then in doing the report, it was also a way to further interrogate or interpret the CRPD to give guidance to the Commission around how the CRPD exposes forms of violence, abuse, neglect and exploitation that is normalised, that is lawful, that is sanitised in our community, so that it would examine those forms of violence, such as denial of legal capacity, forced detention in mental health facilities, forced sterilisation, etc., which I'm sure we'll elaborate on throughout this discussion. But it was really important for me to be able to provide a framework around how the CRPD can expose those forms of violence and desanitise them, and make it clear that they are forms of violence and not therapeutic and humane forms of practice for people with disability.
So much there to unpack. Okay, so let's keep going. You've both used the term human rights, and it gets used so often that I think it's important to just take stock. And could I ask you to explain what this term means for you, and maybe specifically for people with disability? Rosemary?
Oh, look, human rights does get bandied around. Every now and then it really is good to take stock and sort of revisit about what we're talking about. But we're coming back to how the community of nations came together after the Second World War and said that personal characteristics can't be the basis of persecution and a loss of security for the world. So what has happened is we've created a body of international human rights understanding around the basis of human dignity and human worth. But the central element around human rights is that standard of human dignity and human worth is applied to everybody. That those rights are accorded because of our humanness. You know, we are all born free and equal. You know, the first line of the Universal Declaration of Human Rights, I know people think that it's a bit trite these days to trot that line out, but it's really important to remember it. I mean, that is the standard by which you are judged to be a recipient of human dignity and human worth. And it's an agreed position by the community of nations. They came together as a community of nations and agreed to the original declaratory Universal Declaration of Human Rights, and then went further to articulate it into the binding human rights law that we see with the body of the covenants and the thematic treaties. So it creates and operationalises the concept of human dignity and human worth. For people with disability, though, a fundamental aspect of their life was the basis of an exception. Time and time again, the only exceptions within international human rights law are around impairment. And that was the basis for denying and diminishing people's rights. And so you've got a body of agreed laws and standards that are to apply to everybody, but there was a section of our community that wasn't getting access to that same standard of human dignity and human value and worth. But that is the fundamental thing. Human rights is about human dignity.
Therese?
Yeah, look, I think it absolutely is about, human rights is about being valued as a human being. And I think when we were doing the report, we wanted to sort of highlight how over numerous decades now, since the disability rights movements were forming in the 60s and 70s, that being valued as a human being was central really to those movements. It was a challenge and a campaign against the dominant perception of people with disability as broken, as deficits, as different, and requiring different treatment. And that's that really is the crux of why rights are often diminished or limited for people with disability. They're devaluing as human beings, which we refer to as ableism now. So for me, I suppose I've used human rights in a lot of my advocacy work to really push that concept that people with disability are valued human beings, and therefore they should be treated equally and have the same rights as everyone else. They can't be diminished. Their rights cannot be diminished or limited based on impairment. And I think that's what the CRPD does. Well, it is what it does. It states in international law that you cannot diminish or limit the rights of people with disability. No longer is that acceptable. And also because it is a strong tool for people with disability, it enables people with disability to name things that happens in their lives, human rights violations, that are conceived as therapeutic and humane treatment options, the way they're forcibly, say, chemically restrained, secluded or isolated, perhaps in group homes and other institutional settings, the forms of violence they experience, whether that's forced sterilisation or forced contraception, being segregated in specialist environments like special schools, segregated employment options. The CRPD provides the framing and the language to be able to say this is not treatment that should be acceptable for people with disability when it's not acceptable for anybody else.
Mm. Well, that leads straight into what I want to know a bit more about, is you've already given us some ideas. Rosemary's mentioned, and you've mentioned, you know, there are other human rights treaties, starting with the UN Declaration of Human Rights. So could you tell us a little bit more about that point you were just making then, about why did the world specifically need another convention, a convention specifically on the rights of persons with disabilities? Maybe you could tell us what the CRPD represents and what it provides specifically, Therese, building on what you just said.
Yeah, sure. Really the campaign of the disability rights movement was and still is a rejection of what's termed the medical model of disability. So the medical model conceptualises disability as a deficit located in the individual. So it's seen as a deviation from bodily, cognitive and mental norms that is the standard for a human being or a valued citizen, and people with disability deviate from that. So that deviation means that society has responded by establishing law, policy and practice frameworks that focus on medical and expert interventions, diagnosis, treatment, cures, fixing the person to try to fix them to meet that normative standard. So in this sense, people with disability are viewed as different, as exceptions, as other, and they require social welfare and health regimes as a response to meet their so-called special needs. And what you'll notice if you know the disability law policy frameworks, often special needs is what is the term referred to, but which many people with disability just see as meaning special means segregation. So the disability rights movement's largely challenged this and has and in their push for the development of a convention, they asserted a social model of disability, and that model says that impairment is a personal characteristic that is one aspect of human diversity, and disability is the result of the way that society responds to that impairment, and this response results in inequality, discrimination and segregation. So this means that disability is a form of social oppression for people with disability, and that social model of disability has been the basis for disability advocacy and disability critical theory for a number of decades now, and has been very important in challenging systems that continue to segregate and marginalise people with disability. What the CRPD does and why that was needed was that existing international law, soft law, hard law at the time, wasn't really able to perhaps uncover or expose that. It was still largely, people with disability were still being seen in a social welfare health framework, not in a human rights framework, even when those instruments may have been asserting the rights of people with disability. So what the CRPD does, it extends that social model by codifying a human rights model of disability. So in that, impairment is a valued aspect of human diversity, but it's also a valued aspect of human dignity. And this means that rights cannot be diminished or limited because of impairment. So all rights must apply equally to people with disability as they do to everyone else. And this is, it might seem very self-evident, but it's actually fundamental to challenging our current law and policy frameworks that are still embedded with ableism and that still enable rights of people with disability to be diminished or limited. And so the CRPD challenges that and challenges ableism by saying, well, the standard of human beings includes impairment. Human dignity includes impairment. So you can't deny or diminish human rights for people with disability. So the CRPD has a focus on transformative equality, which is about changing structures and systems with positive measures. So it addresses the underlying power relations that underpin ableism. And that's why the CRPD was so critical as a thematic convention explicitly for people with disability. And I'm sure Rosemary has more to elaborate on that.
Please, I hope so.
I don't think there's much more I can add.
No, but go for it.
No, I mean, look, Teresa's really covered the field here, except for, maybe one little point that, I could pick up and run with. But, I mean, again, it is about translating the ideas of human rights, specifically to the unique experiences of and conditions of people with disability. As she articulated, that there was an existing framework of international law disability features in the jurisprudence of the covenants and the thematic treaties throughout the 80s and the 90s and into the early 2000s, and it wasn't as if it couldn't get rights violations prosecuted within the existing framework, but there wasn't the understanding within the human rights field of ableism and how it works and how it operates within our society to deny and diminish human rights. So because the other human rights conventions were unable to either expose nor penetrate that specific unique experience of disability, human rights were largely absent of disability. You know, when the convention was being promoted, but at the very beginning when the negotiations had started, Landmine Survivors, an NGO, had a poster that had a jigsaw puzzle, and you know, disability was the missing piece of the human rights jigsaw puzzle. And that was so true. People with disability were completely ignored by the broader human rights organisations, and the disability movement had little understanding of human rights and international human rights law. So the CRPD process was a bit of a marrying of those 2 points, trying to introduce disability and those core concepts that Therese was talking about in terms of ableism. And it was driven by the language of the social model. But it was about bringing that to the table and trying to get the human rights agenda to understand how that framework was leaving behind people with disability. And I mean, you and I have worked together on stuff, and we've talked about the fact that it's a norm that's deeply embedded and it appears benign. Of course, people with disability need something special. They have impairments. And, you know, impairment is a fundamental part of the human condition. You'd be hard-pressed to find somebody that doesn't have some form of impairment in some way in terms of their human makeup. So, but what it is the further and further that impairment gets away from this standardised notion and norm of able, the further the impairment moves from that into the standard deviation of what becomes disability, is because we all think the bell curve is it, and that we structure our society around that narrow norm. And so people with disability, as Therese says, are seen as other. And so they need something special. And that becomes self-fulfilling. Well, obviously they need something special because they're different, they're other. And because we don't change the system or the understanding of the norm, we reinforce that notion of other, because we segregate, we make it special, so they continue to be seen as other. So even when we try to include, we reinforce other. You know, you bring special ed units into mainstream schools as this notion of somehow that's inclusive. And Robin Banks pointed it out to me just recently. I mean, it's spotlighting. You're putting a spotlight on these kids in these special units. You may as well put up neon signs that say, you know, here are the other people So it reinforces that notion of other in the general public. And so these practices and distinctions were, long held as not acceptable in other areas. And Therese spoke of that earlier. We had moved on from segregation. It's what I said, the first binding piece of international human rights law was specifically about addressing apartheid and specifically about addressing the civil rights issues in America. It came before the two covenants. And so that was the importance the community of nations put on segregation. Yet we still deem it acceptable for people with impairments. So what CRPD does for me as a lawyer, and I probably need a bit more of a life, but for me, I find it really interesting how all the pieces go together to enable people to see the depth of what human rights means in terms of applying it to disability. And it's not just disability. I think if you worked with CDAW in the same way, or not necessarily ICERD, because ICERD's structured slightly differently, but I still think that you could do it. And the great thing about it being a matrix is that it is not just the sum of its parts. It is its whole that gives you what you need to know. So you don't just go to human rights, and specifically the CRPD, because that's what I know the best, and deal with articles in isolation. You need to look at the status of the various articles, what role it is that they're supposed to play in assessing how you get the objective of human dignity. And so that casts an intersectional lens on it. It gives you a set of principles which guides action in a variety of areas. And then you need to look at the interrelationship of each of the articles. And it gives you a depth of analysis that should be able to guide policymakers in seeing what it is that needs to happen to be able to achieve the objective of the convention and the goal of human dignity.
Yes, well, that also, I really like and appreciate that model of thinking of it as a matrix, both as a way to illuminate what's going on, the denial of human rights, and as a roadmap, as a way forward. I find that really helpful. Just picking up on one point, one of the points that was made in this morning's session by Fiona and Paul was the way in which laws themselves, or law, policy and practice, reflected and reinforced, not just addressed, but reflected and reinforced the denial of human rights. So again, maybe I'll flick to Therese and ask you to expand a bit more on the way the CRPD can help us to illuminate the denial of human rights for people with disability in Australia in law, policy and practice.
Thanks. Well, I would certainly agree with that earlier session. It is a similar situation for people with disability. Ableism is still entrenched in our contemporary legal and policy frameworks. And this means that human rights violations are actually enabled or authorised through those frameworks. So I think the challenge for the states that have ratified the convention is they have to come to grips that they need to significantly transform these frameworks to dismantle the power relationships that continue to see people with disability as other and devalued. So just, you know, in practical terms, we still have systems which we think in the community, in policymakers, legislators, think that it's still fine to have special schools, segregated workplaces or sheltered workshops, to have institutional living arrangements like group homes or larger institutional environments for people with disability. We still have segregated transport systems. We don't have accessible environments or transport systems. There has been improvements in that, but it is not fully equal to people with disability. We have special access arrangements, special sporting events, and then we have laws that actually deny autonomy or limit it by removing legal capacity, through compulsory financial management, compulsory mental health detention and treatment, and indefinite detention through justice diversion provisions. So we still have systems in place which we think are either the best way to provide a response to people with disability and their difference, and or to protect them. And yet, what that actually does, and what we're normalising, is segregation. We're accepting marginalisation, denial of autonomy. We're accepting that so-called therapeutic treatments like seclusion, chemical restraint, physical restraints, and some of these cases come out in the media every now and then, you know, locking children in specific purpose cages in schools, seen as a way to address the management of behaviour. All of these are seen as acceptable because they're applied to people with disability, and yet in every other case they would not be acceptable. But this still exists in our contemporary law policy and practice frameworks. And so, so these devalued perceptions of people with disability are a part of the unconscious bias, if you like, of policymakers, lawmakers, of the community in general, that accepts these as the way we need to deal with or address the difference, the deviation that is people with disability. And so, and what we see in, say, policy, so for example, the National Disability Policy is being redrafted now, the next 10-year framework of that, which is meant to implement the CRPD, but which actually does not challenge any of these existing aspects that laws, policies and practice that segregate or deny autonomy, but looks at a way of reforming them or making them more in line with human rights, enhancing them, etc. But there is no genuine and real challenge or action to dismantle those frameworks so that people with disability are genuinely able to exercise their autonomy and be fully and completely included in our society.
Maybe Rosemary could specifically build on the question about segregation in schools. Like that word segregation is so powerful, and I hear you use it, and we, you know, people shun the use of it because no, it's different. As you say, it's different. It's normalized in a way. But maybe you could talk to us a bit more about how segregation in schools is used to deny human rights.
Look, segregation in schools is used to deny human rights. I mean, just basically because really simple things like siblings going to school together doesn't happen. Kids growing up in families, in streets where you don't go to the same school, you know, you're reinforcing within that group of children that Sarah's different. She has to go to a different school. So you're starting that unconscious bias, for want of a better term, from a very early age. Whereas kids, if you put kids together, they're not going to be fussed about, you know, the makeup of one of them. They just work around it.
Can I interrupt there and tell the story, Rosemary, of having to bring one of my children to a board meeting of the Disability Discrimination Centre, Legal Centre, and he came in and everyone around the table, Rosemary was chairing, and there were sign language interpreters and there were dogs and there were, you know, many people with visible disabilities, and we worked through it. And then my son said, "Does anyone have a disability?" Said to me. It was that sort of, what is a disability to a child?
Yeah. I remember, look, speaking of TDLC, the old Australian Centre for Disability Law, but TDLC as it was then. I mean, my nephew, you know, all of 6 years of age, someone was talking about me being chair of the committee, and Edward pops up and he said, "Why have they got to call you by your wheelchair?" Like, for him, I just, you know, thought all these people were being, you know, picking on me because of my wheelchair. But anyway.
Very good.
Out of the mouths of babes.
Yeah, exactly.
But yeah, so it's really, it's simple things like that. And then you get the extreme where you have the case of the school in Canberra. And this is not an isolated case of the kid, that the principal had a special cage built for this child. Previously, kids had been locked in sporting equipment cages and cupboards and just appalling things that if that had happened to any other child, I mean, there would have been a much, much stronger hue and cry than what there was. In fact, it had to be leaked out rather than, you know, not, you know, no one at the school questioned it. No one authorising the financial expenditure. No one coming, you know, they must have told at least more than one person about building a cage for a student. So, you know, it was acceptable within that small community to put this kid in a cage.
Which reflects that ableism view and the bell curve norm, like, oh, well, they're outside of the norm, we've got to do something to protect the norm.
Yeah.
You know, and we've got to manage, constrain, restrain to protect the norm.
And one of the most frustrating pieces of law, discrimination law in our country, would have to be the dealing of the High Court with Purvis. I mean, any discrimination lawyer worth their salt must look at that decision and just go, "Oh, I don't know."
Yeah.
I mean, I try and teach it and I still stand there in front of the class going, "Well, I don't know."
The idea that this child who is reacting to this normalised, narrow, normalised environment is reacting and manifesting his disability, and that all that the school owed him was to treat him the same as other misbehaviours, others who were not fitting within the norm, and that was all that was required to avoid at least direct discrimination.
But they weren't even treating him the same. They were treating him harsher than what they were doing, treating kids with what appears to be their own agency being violent. Whereas Daniel, which the court agreed was acting out of frustration because of his disability, and that it was part of his disability.
And the interaction with the environment was not
And, yeah.
part of the question. Yeah.
Yeah, and the question for the court always seemed to come back to whether he was going to burn the school down.
Yep.
So, I mean, I don't remember any fires being lit in the background to that case, but maybe Murray Gleeson knew something that we didn't. But anyway, I won't pick on the High Court too much.
And let's not attribute too much knowledge to our judges.
It really does, like, education is one of those cornerstone things. And it really does set the foundation for segregation throughout their lives. And it entrenches it within our community. You know, the notion of kids just going to school together is broken. And it's really difficult to get that back again. Because the other kids in the school then expect their society to isolate people with disability. Whereas if you have a true inclusive education system, kids are growing up in an environment where they see flexibility in the way things can be delivered. They see difference and engage in difference about what it is to be written script or what it is to be a spoken word. And they have the ability to communicate with a variety of people in a variety of ways. And so they develop skills that develops them for a human being that can interact with the broad makeup of the human condition. And then they expect that within their workplace. They expect that in their social lives. And so I just think that it's one of those practices that I say is about self-fulfilling prophecies, in the sense that you put kids in special education and it's obvious to all the other kids, then you're just reinforcing that difference. And I mean, separate but equal, and this is what we're talking about. And I mean, what was Plessy and Ferguson, 1896? Plessy and Ferguson was the Supreme Court ruling in the US that upheld the notion of separate but equal for racial education. And it wasn't until 1954 that Brown and the Board of Education overturned that. And separate but equal has been recognised as discrimination, prima facie discrimination, ever since then. It is the basis of ICERD and the negotiations around the Universal Declaration of Human Rights. ICERD was all about addressing apartheid and the civil rights movement in America at the time. Separate but equal was rejected out of hand on a racial basis. Move to the 80s, and we've got women are hysterical. You know, they're chattels to their husbands because they haven't got the capacity to be able to deal with, you know, finances or anything, you know, and heaven forbid they have control of children and all the rest of it. And of course they can't work after they get married. You know, who's going to cook the dinner? And that separate but equal status, you know, you're still human beings, but, you know, you just can't do the same things as everybody else because, you know, you need a guiding hand. Well, that was rejected. I mean, it's been rejected before, yet we don't seem to be able to reject it for people with impairments.
Yes, I would love to. I can see there's some questions coming in about, you know, what we do about it, but so that'd be great. We'll have a discussion about that in a moment. But Thanks for that, Rosemary. Therese, could we take one last question? I want to pose one last question to you about, I mean, the Royal Commission is charged with uncovering violence, abuse, neglect and exploitation. So could you provide an example of how that CRPD lens could help us to eliminate other examples, adding to what Rosemary said?
Well, if I could just firstly add to what Rosemary said, segregated education for people with disability is discrimination. Mm-hmm. And so the Royal Commission, I'm hoping, will name segregated education as a form of neglect within its remit. So I probably just first want to make that point. So it's really important that the Royal Commission starts naming particular practices that have been sanitised and normalised through service system language, like behaviour modification treatments, specialist behaviour support, restrictive practices, therapeutic treatments. A lot of these actually hide or make invisible violence, abuse and neglect, and well recognised and named as violence, and often constituting torture and ill treatment through at the international human rights level. So probably if I could just focus on the issue of forced sterilisation, for example, because the reason I want to focus on that is that Australia since 2005, through numerous treaty bodies, the Committee on the Rights of the Child, the Committee on the Elimination of Discrimination Against Women, the Committee on the Rights of Persons with Disabilities, numerous special rapporteurs against torture, the rights of persons with disabilities, etc., have recommended to Australia since that time that they prohibit the practice of forced sterilisation of women and girls with disability particularly. This really goes to what I was discussing before about laws that deny or limit autonomy. So in Australia, when Australia ratified the CRPD, it also made an interpretive declaration to Article 12, which said that it saw substitute decision-making or third-party consent, as well as supported decision-making, which is assisting a person to make their own decisions, as compatible with the CRPD Article 12. However, 12 years after ratification, this position is just consistently not compliant with the general comments, the concluding observations, etc., coming from the Committee on the Rights of Persons with Disability. But Australia holds firmly to this. So what that means is that there is a view that courts and tribunals can authorise and regulate the non-therapeutic sterilisation of women and girls, and it is in the absence of valid and personal consent of the person concerned. So in human rights terms, that is a clear violation of human rights, and yet it is still it's still authorised in Australia, it's still allowable. So a lot of disability activists or advocates will talk about this as legal forms of violence or lawful violence that is perpetrated on people with disability through our through various laws, etc. And Australia is, and there's a range of these forms of lawful violence that Australia is just not turning its attention to. They are claiming that these are not, these, because they're lawful and because they see them as compliant with the CRPD, that therefore they're valid, and they become then viewed as they're normalised, and they're seen as therapeutic and humane ways to ensure people with disability have their rights, when in fact they are actually allowing for violence, abuse and neglect to occur. So for the Disability Royal Commission, I think a lot of what they need to also be looking at, I mean, obviously violence perpetrated by individuals against individuals in, you know, whether it be disability support workers or mental health workers, etc., by teachers in schools, etc. All of this is really important to be examined by the Royal Commission, but it's also important that the Royal Commission is examining our legal systems, our policy and practice frameworks, and how embedded within them are mechanisms to enable these kinds of the kinds of violence that is very specific to people with disability, but which is not generally exposed within our community or within by policymakers or legislators. So these practices remain justified in Australia. And just probably one final point about that, particularly forced sterilisation, forced contraception, forced abortion, forced menstrual suppression, etc. These are forms of gender-based violence that are not addressed at all in our national frameworks to deal with violence against women, because the national plan to reduce violence against women and their children is framed in the context of intimate partner violence. So within family settings, generally speaking, that's how it's framed. So it doesn't go to all forms of gender-based violence, such as these forms that I've just mentioned. It doesn't go to all forms of gender-based violence, nor to the specific living situations where women with disabilities often live in terms of institutional environments. So there's significant intersectional work as well that needs to happen in relation to the rights of people with disability.
Oh, so much to think about. I think even that one point you made a moment ago about, yes, the Royal Commission has to focus on individual acts of violence, but it's that, to say it's the systematic use of law, policy and practice to commit violence and to normalise that violence and to sanitise that violence. And so hopefully using CRPD to illuminate that, to see it in the system. And it ties in very well with the panel this morning, you know, talking about, Paul mentioned this morning that it's not that the law is not doing its job. The problem is the job is to do this, right? That the job itself, the law itself has the biases embedded in it. So it's achieving it's what it's set out to do in a way, and we don't see it. So uncovering that, revealing it, using parallels to see it seems, you know, a first step, but then actually doing. So can we move on to, there are lots of good questions coming up, and I'm just going to pick up some threads in them. Robin Banks says, the idea that segregated education is separate but equal is pretty generous, Rosemary. So I agree. But just one of the threads is that question about, I'll read one of them. Can I ask about the impediments to a more holistic and inclusive thinking about how these things can be overcome? And picking up on another thread, it's particularly the way in which I'd say the ableism says, you know, we need to not spend money on the extra, right? That we've made other and then said, you know, so this is cheaper, the norm is cheaper or better or something. And, you know, if we really want inclusive education, it's going to cost more, you know, the floodgates. So what do you see as a way forward? You talked about CRPD providing a roadmap, right? What do you see as a way forward, in particular about how to encourage that more holistic, inclusive, human rights way of non-ableist thinking? Rosemary, I'll start with you.
Oh, look, this is going to sound pretty trite, but I think it's leadership. I really do think it's leadership.
Oh, forget that.
Well, and I mean, what I'd like to say first is that in lots of ways, it's not pure ableism that's the blockages these days. It's vested interests. Mm-hmm. So, you know, states and Commonwealth government have invested significant money into things like bricks and mortar around special education. Mm-hmm. there are industrial relations mechanisms that are in play, both within segregated education, but also within segregated living environments and segregated employment environments. So there are significant vested interests that have very powerful sway. And yet people with disability have a very limited voice in that power relationship. And so it really is one about leadership, because the capital that is spent in supporting this segregated environment, if it was repurposed for inclusion, it could be a very different tally of what it's going to cost. But we don't have that discussion. The vested interests aren't seen because of this benign norm that keeps fulfilling the notion that we need different, we need separate. You know, we're being caring. We're being very caring, and it's all very special and very specialised, and it's needed. So I know leadership is a difficult thing to sort of encapsulate and say what it is, but it's not going to be an overnight process. But we need, at some point, for leaders to recognise what the issue is. And I don't think that's happened yet. I really don't think that's happened yet. Because otherwise we would get past the want to always talk about disability in terms of care. We found with coronavirus that you know, the way they wanted to respond was purely through the National Disability Insurance Scheme. Because obviously, if people have got, you know, their disability supports, so their care packages, as it was being said, they're fine. They're being cared for. But the issues were bigger and broader, and there's more people in Australia with impairment than what there are on the National Disability Insurance Scheme. And they were completely oblivious to that. And so people with disability didn't get factored into the response to COVID until very late in the game. Yet, because of the situation, their living environments, many of them were in very high-risk situations. You know, they kept talking about aged care homes. Well, many people with disability live in congregate care. And so they were just as vulnerable, but there was no focus on disability at all. And so it's about recognising the issue for what it is, and then putting in place the mechanisms by which it can be systematically reviewed and transitioned. And so, I mean, I think it's a step-by-step process. It's not going to be an overnight thing. But unless you make some significant reform challenges, take some significant reform challenges on, we'll get nowhere, because at the moment all they're doing is trying to tinker within a service system that maintains all the violence, abuse, neglect and exploitation. And that's fundamentally not going to change, because we've been doing that for 30 years.
Therese, give me some hope.
Well,
Or some
I am a
ideas.
bit-
So what are your
Yeah.
thoughts about? So I was
Well,
a bit
look,
heavy,
I
sorry
think-
there, but some ideas about what you think are the best tweaks for raising awareness and getting leadership or change.
Well, I think, look, I think, you know, leadership's one part of it. And I absolutely think the issue of vested interests is really critical in this. But there's also just a lack of understanding of the CRPD and its depth and how its standards and principles. And so somehow in Australia we can talk about and have policies that talk about the rights of people with disability and disability inclusion strategies, and all people with disability should be included and fully participating, and we need to respect what they're saying, etc. And yet, and there's still a focus on maintaining the systems that segregate and that deny autonomy and that forcibly treat and you know, and force medical interventions in the guise of therapeutic treatments, etc. So there just seems to be a disconnect between what is understood as the rights of people with disability and what is actually understood as needs to happen. So nobody says this is going to be easy and that this isn't going to take time. But so just the example of education, there's been calls now for a decade for a national action plan on inclusive education, using the guidance that's come from the Committee on the Rights of Persons with Disabilities, so general comment number 4, around inclusive education. I think it's number 4. And developing a plan of how does Australia move to that goal. What will it take? Well, obviously it's going to take, you know, shifting of resources, for example, from the specialist system into mainstream education. It may take different way of approaching training of teachers, and it may need to look at different kinds of curriculum, methodologies, processes, etc. But all of the, you know, there's enough people in Australia who have the expertise that could work with government to sit down to develop such a national plan with the timeframes, etc., to move towards the system. What has to come, though, is a commitment to that system, not the constant refrain of, oh yeah, well, of course, you know, we support inclusive education, but for some kids or for some people with disabilities, it's just too difficult and we really can't have them. They're so different. We need to, so it comes back to that ableist. There's such a deviation, they cannot be included. And the issue of cost is, you know, if we look at women's rights or other rights areas, there's always been this argument of cost. How can we have women, how can we have maternity leave? It's going to cost too much. Employers won't be able to do it. How can we enable women to stay on in employment after, you know, they're married? How can they have equal rights to inherit property, etc., etc., etc. All of these arguments. This is the kind of thing, this is the transformation. We need to bring it into the disability rights area and not leave people with disability behind, in a sense, and say, well, we've done it, you know, we've had all of these rights discussions and we accept it perhaps for other people, but we just can't quite accept it really for people with disability because it's just too hard, it's too costly, and so they have to bear the burden of their own, of their segregation. They have to bear the burden of, you know, how they are treated, etc. And so that has to end. And I think it's leadership, it's actually understanding and making a commitment to the principles and standards in the CRPD. And it's about having standing mechanisms that have people with disability through their representative organisations at the table to be looking at what is the national plan moving forward to genuinely transform systems and structures that continue to segregate and discriminate and treat people with disability, you know, leave them in situations of inequality. So,
and not accepting that argument that it costs too much, as if cost is a factor, and as if we really understand those costs, you know, where, as Rosemary said, spent over here, not over here. How about we put it together? Can I move on to, sorry.
Can I just add a point? I mean,
no, we're all talking at once.
Sorry.
Rosemary.
I just wanted to add to that is it was incredible. We spent 22 billion, you know, we committed 22 billion to the National Disability Insurance Scheme, the biggest social investment since Medicare, yet we built into it segregation in living and supported substituted decision making. We built it into the system, yet it was supposed to be the shiny new move away and the, you know, control of people with disability to get out of those situations, yet we built it into the legislation and framework.
Which is that example, another example of what you're saying about, you know, the law, policy and practice, having it embedded in it. One of the questions that's come up from Robin Banks is the way in which in our anti-discrimination laws, and I hear this all the time, you know, we have these anti-discrimination laws and they say, oh yeah, but disability is different, right? And again, it's that sort of, oh yeah, you know, like we have race and we have sex and we have, but disability, people with disability, well, that's different. And Robin Banks points out that, you know, it's only in the anti-discrimination law in respect of disability, so the DDA, that we have a defence of unjustifiable hardship, right? That if not discriminating imposes an unjustifiable hardship on you, you're okay, you're allowed to do it. And I do understand that it's an individual model and one particular business alone should not be making, you know, out of the blue. But why are they allowed to design systems? Why are they allowed to design car parks, as you've given examples before, Rosemary, or airline policies around a narrow norm? So Robin suggests, you know, it's a technical but a bigger question, should we remove the unjustifiable hardship defence in disability discrimination law? At least start with government. Rosemary?
Oh, look, I definitely agree. I mean, it's been something that, it's a position that I've agreed with for a very long time. I don't see the basis, I mean, especially when you're talking about things that aren't about putting an impost onto a small employer or something like that, when, as you said, you know, government procurement. Why should that have an unjustifiable hardship defence to it? That just seems preposterous, and that should be the leadership that we've got, that they should be able to say, well, no, that would be discriminatory and so we shouldn't, and no. So government shouldn't be able to claim unjustifiable hardship. Yet governments do all the time, because education's one of the biggest areas of DDA cases that go forward to the court.
Rosemary, I know you've got 4 years on the committee, but I'm afraid there's already a vote for Rosemary for PM in the Q&A. So just gear yourself up for at the end of that committee session.
Yeah, someone would want me to join some political party if I'm supposed to do it.
No, you could go independently, and we need leadership apparently. Therese, do you want to add to that? Not to the vote for PM.
Yeah. No, look, I just agree with the unjustifiable hardship provision has been a real bane of contention for the disability community for a long time, particularly in terms of asserting their rights. And I mean, there's many problems with the DDA, the unjustifiable hardship being one of them. Yeah, look, I would just agree that is an issue and an anomaly that really needs to be removed.
Therese, there was a specific question here that was following on something you mentioned before. It says, what is Australia's response to its consistent failure to meet the review requirements by the CRPD committee? Will the alterations to interpretive declarations hold Australia accountable, all of which is considered lawful and justified in Australia? Do you want to comment on that?
Well, Australia's been reviewed, well, by a number of treaty bodies, but if we're just talking about the Committee on the Rights of Persons with Disabilities, it's been reviewed twice, in 2013 and 2019, so just probably about a year ago. When you look at the government reports to the committee and you listen to the constructive dialogues, they are really, I find them quite infuriating, because they just repeat the same arguments over and over again and maintain that their interpretive declarations are compliant with the CRPD. So substitute decision making is compliant, and so we don't need to reform anything. We just go along with the systems that we have. And they have interpretive declarations to two other articles, 17, which enables compulsory mental health detention and treatment, and Article 18, which enables discrimination against migrants and refugees with disability who want to have visa, through the visa application process. So they continue to maintain that their systems are fair and just. But I think what's infuriating is that even if those interpretive declarations, when they first made them, when they ratified the convention, were to give them a little bit of breathing room to assess where they stood and to consider how they could shift systems or move forward, they're not doing that. They're just using them to maintain the status quo, and it is actually preventing reform. And we've had sort of 12 years of jurisprudence from the committee now, which says exactly the same things, that these are not compliant. They give general comments that explain what is compliant, and as Australia just continues to repeat the same arguments. So they're not even moving forward. And even in terms of Article 12, in terms of legal capacity, in 2014, the Australian Law Reform Commission provided its report on with recommendations on how to ensure compliance with Article 12. And one of the key things was the establishment of national supported decision-making principles and a framework to guide the shift to supported decision-making. Well, there's been no response to that, or no moving forward on it. So even where there's been credible investigation and examination of these issues, they are ignoring their own advice from within Australian bodies, etc. So it's incredibly frustrating for advocates to continually be raising these things over and over and again, not just with the Committee on the Rights of Persons with Disabilities, but the Committee on the Rights of the Child, the Committee on the Elimination of All Forms of Discrimination Against Women, the Committee Against Torture, the Human Rights Council, etc., which is a process. The Universal Periodic Review is happening now, and Australia will be reviewed in January 2021. So all the arguments that have been put forward by advocates remain exactly the same all the time, because there is no shift.
Oh dear. So drawing upon that, I mean, there are other questions, but I mean, I would like to end on the hope that the participants here have, been enlightened. It helps me to hear you give examples and explain the constructs and reinforce some stuff that I know, but I need it to be said again and again and again to unpack my own ableism, to see it as the first step. And to see how it's embedded in law, practice and policy, that it's not just these individual acts, but it's embedded in these things. And so hopefully that at least this bunch of people now feel a bit more empowered to be able to go out and to start to challenge the segregation, to start to challenge the denial that oh yes, human rights for everyone except for, if human rights are human rights, they are entitled, given to all humans. So I would like to, on behalf of all the participants, particularly like to thank you, Therese and Rosemary, for helping us to understand that and to empowering us, a bit more understanding, a bit more knowledge and gumption, hopefully, to go and do more. There's been another vote for you being PM, Rosemary, so I think you're up for it. And many thanks in the questions and so on. So thank you, Rosemary, and thank you, Therese.
Thank you very much, Linda.